We doing chill stream Sunday, bro. Chill Sunday stream. Shit. Open this bitch up. You seen what Melly doing?
Is there something funny? They want to kill my client. That's what we're playing with his life.
Stop. Stop. The Evans has now been in custody for 2,202 days. Okay, and
Outside of this.
Judge, he's actually lying to the court right
Grab
now.
your food. Grab your food. Grab your drinking. Chill. Let me just keep my little ass up here. I'll make myself look, yeah. You know what I mean? Tone that shit down a little bit. Yeah. Right there. Here we go.
I'm embarrassed for both sides. I'm embarrassed.
And it was
You're
your
not
fault
the
that-
trial.
Yes.
This is the decedent's cell phone.
And now, 2 years later, I'm being accused of trying to kill Danny Polo.
YNW Melly appeared in court for motions. Melly's lawyer, Raven Liberty, is being accused of trying to kill Detective Danny Polo. What I just said is not a joke.
Wait, hold on.
Explains to the judge why she thinks the search warrants were executed, and she says it's because of that.
Wait a minute. Did I skip something? Did I skip something? No. We watched this on stream last time, so. Oh, we watched it too. Bet. We watched it too.
YNW Melly's
I ain't gonna
Thank God
even
this
watch
judge
the
is
title.
set on the September 10th trial date, and he's not budging whatsoever. So that is set in stone, and everyone else has to figure everything else out. Hit subscribe. Let's get right into this. Let's go. All right, here comes Melly walking in. Doesn't look happy. Understandable. Was it
Don't look happy at all.
2,100 days in jail? Shaking his head.
2, motion limited to exclude James Howard irrelevant and immaterial detention communication. Motion limited to exclude irrelevant and immaterial TikTok video of meat baby. 4, renewed motion to take deposition of Christine Brown.
Hearing a judge say Neek baby, whatever that is, I think it's a TikTok username that made a random video that the state submitted as evidence.
Defendant's motion to strike from the alternative response to the
Meat
state
baby,
of Florida's
come on.
motion to allow former testimony of Felicia Holmes. That's what I wanted to get done today. State, I'm being told that there's a medical issue with Ms. Buckley, is that correct?
That's correct. My understanding was the course of a a notice of hearing deadline was Friday 5 p.m. It was moved to Friday 9 p.m. because Ms. Liberty was stuck in court and needed time to prepare it. The notice was not actually filed until Saturday, so they failed to comply with the court's requirements. So at this point, the state's position is no notice of hearing is properly filed and there's nothing to be heard today.
I'm gonna just move my ass
Does the
over his
state
ass.
want this trial to happen? He's saying that she was late.
I love you,
12
man.
Hours.
I ain't gonna lie.
She filed
You're
it
a
on
cool man.
Saturday and was supposed to be Friday evening. Do these f***ers want this trial to go on? Like, this is fucking insane. He just said they don't want any motions to be discussed. Are you fucking kidding me, dude?
What do you want me doing?
Judge says so you don't want to do anything today. What the fuck?
The funny thing is, the great thing about those cameras in this room is everything gets recorded. I did say Friday at 9, and then I actually stepped back because I knew I was setting myself up for failure next week. I do it Saturday. Taylor then responds, oh, as long as we get it before the beginning of the next business day, which is Monday. So they've had it. Most of these motions, Judge, were filed for over a year.
Ooh.
I will bring the court's attention because last night in preparation of this, I know the last time we were before, they objected then about hearing motions because they were filed under the tampering case. Yet they've filed several different motions saying it doesn't matter what case number are on the motions because the discovery is interchangeable. I'm quoting exactly the language from their own motion. So it's good for them when it's convenient, and now it's not convenient, so there's another excuse. It's been a year. Everything was properly noticed. I will also add, there's no written order setting a filing deadline or allowing them to file a response within a certain time frame. That was oral. So as we all know, oral orders don't count for anything. They need to be written. There was no written order. I did ask to extend it. We are ready to go forward There are two state attorneys sitting over there. Understandable. One of them's missing. Mr. Griffiths, is there something funny?
There'll be no attorney.
She says there's something funny.
You can direct your comments to me. All right, y'all
So
have
we're
5
ready.
years to talk to each other about things.
We're ready
You
to
just
go for
talk.
it, Judge.
Okay. Listen, state, I get what's going on. I'm not going to criticize when I was done here, but I read all these and I went through the entire court file in preparation for the hearing today. Most of these are fairly straightforward. Over your objection, I'm going to hear them, but if we get to some specific factual issue that you say only Ms. Buckaloo has the particular knowledge to
Oh, Buckaloo's not there. That's their f***ing fault. This is a hearing that's been scheduled for weeks. Oh my god, just because Miss Buckaloo's not there, that's so annoying.
address, you can certainly tell me that. But again, I find most of these to be very straightforward. Ms. Liberty, I went on CMS yesterday and I went on Odyssey. I can't find any court order dated February 9th, 2024. Well, I'm just looking at Judge Murphy's order. He said this order is related to the motion to compel discovery filed on February 6th, 2024.
So there should be two motions for rehearings filed by the state.
So the reason why he is all confused, the judge, is because he's a new judge in this case, and they're trying to find orders and motions. He's struggling to find right now in Odyssey or whatever the system where they find all that.
Number 2 is defendant Jamel Demon's motion in limine to exclude James Howe's irrelevant and immaterial detention communication.
This is the 600 jail calls with someone named James Howard. I'm not joking or over-exaggerating. It was actually 600. Apparently, he only says the name Melly once out of 600 phone calls, and it's about talking to Melly in jail or something. Defense obviously is saying this is bullshit and irrelevant. I don't know why
They
the
just make
state was
him,
so horny for
like,
it, but
So
Joke
you're
out of
talking
shit.
about, this is a motion limited for trial. And I read the motion. Anything else you want to tell me in support of your motion?
This judge, it was close to, I want to say 84 hours worth of phone calls.
holy shit. 84 hours of phone calls one of them had to sit through.
That were given to us that December. We were set for trial. I was always of the position it was given to us that late in the game in order to make it continue it. Nonetheless, I had a group of students go through those phone calls along with myself and the investigator. When you look at the police report that was authored by Garrett Steele, investigation that's being done by Polo into this James Howard, and I believe the Alwood game. Some reason then references James Howard in this police report, saying he was listening to phone calls by James Howard, and then he hears James Howard telling somebody on the phone call that he has to do something for Melly that day. We had the opportunity to depose Detective Polo as well.
So it's Danny Polo that was listening to James Howard jail calls and heard this.
I asked him this very question.
Oh,
Over
course
80
that's
hours with the phone calls. There was one phone call, and that one phone call in this batch of phone calls tells us nothing other than him saying, oh, I have to talk to Melly today. Now I have to do something for him. Now I got to call people for him. Nothing at all. During the deposition of Detective Polo, when I started questioning him, hey, I went through all these phone calls. Could you please direct me to what phone call I should be looking at? What batch of phone calls? He then tells me, it's not this batch of phone calls. It's a batch of phone calls that would go back to 2020 and 2021. We are dealing with the tampering. I believe we're spanning from April of 2023 until August of 2023, somewhere in that time frame. Detective Polo, in his own words, was the only time that he had heard James Howard talking about Melly, would have predated the incident, i.e. 2020, 2021. Nonetheless, those phone calls are not in this 84 hours of phone calls.
Dave, can you respond?
Yeah, like the board would see on that, there's still the outstanding issue whether Mr. Devin still wants to celebrate representing him. The state has raised the issue with the conflict of interest. The court has pointed that out. That was going to be one of the first things we were going to address with you today, and we still need to address that because obviously if he does not want to celebrate representing him, then there's an issue that can argue the motion.
Oh my god. See, now the state didn't even respond to the motion. They're just saying,
Yeah.
we need to figure out if Miss Liberty on the right here is still going to be Melly's lawyer. Because they think she can't be his lawyer anymore. They don't want her as his lawyer. They literally submitted a whole motion saying that.
I already had that discussion, so I'm sure if there's something that you want to let me know, you're going to let me know.
Yes, sir. The state filed a written response, I believe it was yesterday. This is one that was Buckaloo prepared.
Like, she's
But,
already there.
as
Yes, I
pointed
think it's the
out
answer is
in the
yes.
argument, the state is not required to disclose which calls it intends to use in a trial. But other than that, we are going to rely on the responses.
Isn't that so crazy. The state is not required to specify which calls out of 80 hours of calls they're going to use.
So I did check the docket this morning. I saw no written motion. And it's funny, Judge, that they were starting this hearing out saying they wanted to continue it because they didn't get proper notice. A notice of hearing from, I don't know, almost 2 weeks ago. But in the evening, they filed something before Ms. Buckley went to the hospital.
This is the second time. You need to look at me and address things to me.
Right.
I could give you a lot of adjectives about what I think of this entire procedure. The funniest time to see one.
Okay.
So, anything else you want to tell me about this?
No, Judge, I would say there are no material phone calls that would even go to the nexus of witness number.
Judge is getting annoyed. He's saying this shit's not funny. Bro said he got a lot of other adjectives in mind.
So,
I don't understand this shit.
Fucking
Fucking 5 years? Like, no, more than that, shit.
What is or what is not going to be relevant.
By now, you've probably heard of DeepSeek. It's now the #1 app on most app stores. But every conversation you have through their app gets stored on Chinese servers and is subject to Chinese censorship. I encrypt up to 80% of the plant.
But just without prejudice, you can certainly raise the issue if the state tries to introduce any of these phone calls at trial. Give the appropriate objection, and I'll give you the appropriate ruling. But in a vacuum, having never heard any of these calls, I have no idea what the calls are, nor do I have any idea what the evidence is going to be at the trial. So that one's going to be denied without prejudice.
So he denies that first one.
All of these, it would be the same thing. I don't know what the evidence is going to be at the trial. And there's actually already been a trial, and the evidence may be the same as the first trial, or it may be completely different. I have no idea. But I can't make a decision now without there being one witness, without being one piece of evidence, without hearing the answer of one question in anyone's testimony. You may be right. These things may be not relevant, and the state may not even try to introduce them. But I can't give you a pretrial ruling, again, in a vacuum when I haven't heard it.
This video is after the homicide. I don't even believe the individual in the video doesn't even know Mr. Dennis. So there is no relevancy to the homicide and my client. If it was filed, I guess, because they have it interchangeably with the tampering, there is no, I guess the tampering in this case would be Mariah Hamilton. There is no evidence in that video of Mariah Hamilton. There is no evidence in that video of anything, period, that has to do with this tampering case or this homicide case. I believe it is the state's burden of detention, not our burden. It's not relevant, period.
I don't agree with you. It's not the state's burden. This isn't the trial. So, state, anything you want to tell me?
No, we would ask Your Honor to defer ruling depending on whether or not it comes up at trial. Depending on the evidence, it may become irrelevant. That's provided, and we can't tell you at this time that we intend to. We can't say we don't. We provide it to defense, and should it become relevant at trial, it will be subject to all appropriate relevancy objections, and we can address it then.
Thank you. So for this one, I'll enter a written order. Again, the defense motion is denied without prejudice.
Denying all these until the trial starts, pretty much.
Number 4, renewed motion to take the deposition of Christine Bradley.
Emails, they get even more confusing. Your lead detective on this case, Garrett Steele, said under oath that he never read these emails. These emails are referenced throughout the affidavit and the arrest, stating that the deposition and these emails prove there was an official proceeding that Mariah Hamilton did not go to. Again, Garrett Steele said he never read the emails. Danny Polo then says it's not his case and he can't comment on the emails. It's really unclear from reading them what's happening. And again, there were certain emails that were not even provided that we later were given from other sources.
State your response.
First, that's an inaccurate statement. The emails were actually provided. That's actually in the state's response to one of Ms. Liberty's other motions, but turning specifically this one, state filed a response back on January 2nd of 2024. We're relying on that response.
Defense wants to depose Christine Bradley, who is the former prosecutor in this case that got kicked off from the first trial.
State, let me ask you this. Is Ms. Bradley listed as a witness?
Yeah.
She's not. You're not call.
Yeah.
If she listed by you all as a witness?
Yes, Judge.
So the defense lists a witness, pursuant to the rules, and if you intend to call her.
Yes.
So
Interesting. That will be fucking crazy if they call the former prosecutor as a defense witness. Oh no, dude.
We do intend on calling her as a witness because she has, I believe that because as far as, or correct me if I'm wrong, as far as the other issue before she testified, anybody? No. All right. She wasn't there. I want to call.
tell me what you need to do.
very.
Give me a couple questions you want to ask her.
I want to get to what other emails were there that she had between Christopher Barris, showing the efforts to get Mariah Hamilton to this deposition.
So with Ms. Hamilton, that's the person who just got put on an ankle monitor.
Yes, we need some clarification from the previous state attorney when you talk about these efforts to get her to deposition. And then we are provided emails, and those emails tell us something totally different than what's being
Is Ms.
talked
Bradley
for.
listed as a witness in the 23 case?
She is not.
Is she listed by you as a witness in the 23 case?
Not at this juncture, Judge, it took the appeal before we got that far. And this, again, was the motion that was pending, coming up to getting a
Well, do you want to ask her questions about the homicide, or do you want to ask her questions about the tampering?
about the tampering thing.
And she's not listed as a witness in either one, by either side in that case?
Okay, so with the tampering, this motion had initially been filed. We hadn't got to the point where we were going to do, I had not did a witness list yet on the tampering. She is listed, however, on the homicide.
You?
Yes,
Defense is trying to get to the bottom of some clarification with emails, and they think they're lying about something with Christine Bradley, the former prosecutor.
I can take depositions of anybody with relevant information, which Ms. Bradley is, whether she's
Yeah, I
listed
agree.
or not
What do you
listed.
need?
Because they filed a protective order and won't allow me to do it. That's why I had to then file the first motion.
But then the next sentence says, after receipt by the defendant of the discovery exhibit, the defendant may, again, without legal report, take the deposition of any unlisted witness who may have information relevant to the offense charge. So you don't think it's a deposition?
Except for the fact that Judge, she is a state attorney, her role as state attorney, she was entitled to protection, she filed a protective order, in part because everything that Ms. Liberty is asking for has been turned over. Emails, whatever else that she's been looking for, has been turned over, I believe actually several times by Ms. Bucklew, again, one of the issues going forward today, not having her here, but she was the one that provided copies of everything.
Well, she's not an assistant state attorney assigned in this case.
Ms. Bradley? No, she's still,
What's the problem?
it's no different than if somebody is a case filer or works on a case. There are work product protections involved in terms of what Ms. Liberty intends to ask. And we sought that protective order because she's entitled to those protections as a prosecutor, and also because, based upon our response, that it is unnecessary. I'm sorry.
I guess that's where Ms. Liberty, I'm still not following you with what the relevance is. Tell me what, let's say she wrote 1,000 emails back and forth. What is the relevance?
Because if you go to the,
So it's emails between Christine Bradley and Mariah Hamilton's lawyer. It's a great question. I don't know if it's relevant or not, but
because if you go to the arrest affidavit, under the witness tampering, these emails that Ms. Bradley authored are specifically referenced in Garrett Steele's police report, right? He says that he reviewed emails between Christine Bradley and defense counsel coordinating the deposition of Mariah Hamilton, that she showed her numerous attempts to get Mariah Hamilton to this deposition. That is Garrett Steele's words. We deposed him. I put in the motion. Garrett Steele then says, I never read a single email. I'm depending
But I
on
mean,
him.
his report's not going to be in front of the jury. I mean, none of that's going to be in front of the
It is relevant to these emails because it is part and parcel of everything of the basis of arresting Mr. Dennis. They weren't saying Mariah Hamilton didn't show up to trial. They said Mariah Hamilton didn't show up to a deposition. The other reason I need to depose Christine Bradley because it's really important how that May 5th date was given, all right? So when we're trying to go with the premise that my client tampered with Mariah Hamilton because she didn't go up to this deposition, we need to hear from Christine Bradley and find out what efforts she made to coordinate this deposition with Christopher Barris. That is why she was also supposed to turn over these emails. And guess what? When you read these emails that get turned over, Stuart Adelstein's emailing with Ms. Bradley, trying to ask for dates for the deposition. There was not one single email that was provided to us in Ms. Buckley's response from the time that Christine Bradley gives us dates to the time that Stuart picks them. She was not contacting Mr. Barris. That is, we can't see that at all from her emails. We finally get an email from her April 18th that's copying an email from April 17th. That appears to be the first email that she sent to Christopher Barris about this deposition. So for the state to not coordinate a deposition with a witness and then to cover up their negligence, turn around and file a criminal charge against the defendant, when in reality, if we got her up there, we would hear from Miss Bradley that she never properly coordinated this deposition, that she
No,
never
she don't.
told Christopher Barris. And all the months leading up to us trying to schedule this, Mr. Barris, from these emails, was never contacted. And that's what we need to depose her about.
So defense thinks that Bradley lied about trying to put effort in getting to depose Mariah Hamilton. That's the whole point of this.
There is an email in here also that was provided where she talks about numerous phone calls and text messages that were sent to Mr. Barris. I don't see those. We don't see the numerous text messages. We don't see the numerous phone calls. So we need to depose her on this limited subject of what she did. When I asked him, under the statute, tell me what official proceeding is, he goes outside of the statute and tells me anything that's involved with the lawyer, that's an official proceeding. That's your lead detective. They want to kill my client. That's what we're playing with, his life.
Stop, wait. You just told me this has to do with the tampering case. No one's getting the death penalty for the tampering case.
Yeah, but they want
Ms.
like,
Bradley's testimony in the murder case is wholly irrelevant, so
they want
let's go
like
back. Are we talking about the tampering case, or are we talking about the?
we are talking
homicide
about the
case?
tampering, but they're also intermingled with each other. So it's life in prison.
Okay, I got it. Respectfully, over the defense objection, renewed motion to take the deposition of Christian Bradley, and denial.
Shoots that one down quick. She said they're trying to kill my client. That was intense.
Find that her testimony would be relevant in any way, shape, or form. It's not relevant in a homicide case, nor do I find that it's necessary under what's been followed with the tampering case, the information, or what's required to be proven pursuant to the jury instructions. But you're telling me you listed her as a witness, that means you have a good faith belief that you're going to call her as a witness, so you can call her as a witness. Ask whatever questions you want from the jury under oath, but that's going to be denied. Defendant's motion to strike and/or in the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. So this kind of mirrors the same as 2 or 3. I mean, I have no idea if Felicia Holmes is going to, she testified at the first
She
trial,
testified in the previous trial, Judge. We actually started to address this motion in the previous hearing on Judge Murphy. Ms. Allenstein actually put a stop to it because he brought up the issue that the court has brought up, which is until she actually takes the stand, we're not, outside the presence of the jury, we're not actually going to know what she's going to do. She has filed through her attorney a notice of her right to invoke her Fifth Amendment privilege. And I believe when she was in court, she was either going to say she was going to invoke her Fifth or say that she didn't remember. But I think what's going to end up happening, as Mr. Allenstein suggested at the previous hearing, once we get to her as a witness at the trial, she'll be brought in outside the presence of the jury, and then we'll have to conduct the inquiry.
so you want me to defer on this until we have a proffer from her? And
Correct. We obviously anticipate her invoking or saying she has no memory, but until it actually happens, I mean, she might not show up, which is another issue, which we might then saw to see.
She's on a bracelet, but she didn't show up where they'll have her arrested.
Okay.
Right, but until we reach that point.
Anything else you want to
Yeah,
tell me
but
about?
they filed this motion, as I put forth in my motion to strike. Actually, when Bradley filed it, they incorporated it, they have not withdrawn it, so it's their intentions to move forward. Mr. Griffiths is correct, she does have to show up here and testify. That's why I put that email there that Ms. Bradley sent. But that email is sent the day before this motion is filed, saying what? I've done all the research, and from my research, it shows that Ms. Holmes would have to show up to court and plead the Fifth. I'll file the motion if she shows up to court and pleads the Fifth, and then she doesn't have to come back here anymore. I find it disingenuous and unethical for the state attorney to be advising a witness to plead the Fifth on the stand, much less advising them how to testify whatsoever.
Didn't she have her own lawyer?
She has her own lawyer, Mr. Barris.
You're not giving her.
I'm certainly not giving her any advice.
Go ahead.
But that is Ms. Bradley.
Ms. Bradley,
Telling
no longer
Ms.
is
Barris, but you are moving forward on her motion. So that is Ms. Bradley telling Mr. Barris that your client needs to show up and plead the Fifth. So now Mr. Griffiths is saying, oh, we are going to move forward, but she needs to show up and she needs to plead the Fifth. If it's his intention and he knows that she's going to plead the Fifth, it's not proper to bring that up in trial or in front of the jury.
Well, I agree. I mean, that won't happen in front of the jury.
So what it sounds like is actually agreeing, judges. They're not going to be moving forward their motion to have her deemed unavailable. They plan on having her come to court. So I move to strike the motion because it seems that's what they're saying themselves.
I'll defer on your motion at this point.
Defers the Ms. Holmes motion.
Okay, number 6, motion for scheduling order. At the end of the day, I consider this more of a professional courtesy. If the parties want to be courteous to each other, that's always kind of preferred, I guess. But if the parties don't want to be courteous to each other, you don't have to wait for one state attorney to tell you, set the deadline.
Okay.
Mr. Devens has now been in custody for 2,202 days, okay? And if one state attorney is not available, maybe one of the other 2 assigned in this case can stand in. And if all 3 are not available, maybe one of the other 150 state attorneys upstairs might be able to sit in. But
Sheesh. He's saying they got 150 state attorneys upstairs. These motherfuckers need to get working. They're not delaying this trial no longer.
The other issue has been is that Ms. Liberty must properly coordinate and must properly notice the state. This is a I know, but
I just read the rule. She doesn't have to coordinate anything. She has to make a good faith effort.
Right, she has to make an effort.
She has to put a certificate on the bottom that says, so I tried, they told me no.
So what has happened in the past is that she has asked for dates, we provide dates, and then she schedules dates out or times outside of those.
Judge, he's actually lying to the court right now. I've sent it out every email.
Please, stop.
She's saying he lying, man.
You all feel that has been submitted
We'll file for
in error. You file the appropriate motion, and then what would be a wonderful use of this court's time is I'll have a hearing with 6 lawyers, 7 lawyers, because you all can't say no. So in case I'm not making my feelings on this point clear, I'm not prejudging anything. But talking to a judge about trying to agree to set depots in a death penalty case is absurd. I'm embarrassed for both sides. I'm embarrassed. The motion for scheduling order is not, you don't need a scheduling order, set your depots. I'll enter the appropriate written order. Next.
Yikes. Bro said y'all don't need this shit. This is embarrassing.
And his third motion to compel the forensic images of the cell phones belonging to Christopher Thomas and Anthony Williams. I read this motion.
That nigga looks
So,
salty
State,
as
let me start
hell.
with you on this
Look
one.
at his face, bro.
Do you have anything from the cell phone downloads of Christopher Thomas and Anthony Williams that has not been turned over to the defense at this point?
Judge, again, this one is Ms. Buckaloo's purview, so she filed a written response. I think the issue that Ms. Buckaloo had, and I'm probably going to be speaking out of turn on this one, is that there are contents of the phones that are not relevant to the case. And so some items have been turned over, but not all the items. This is one where I am lacking of knowledge.
That's okay. The state doesn't get to decide what's relevant and what's not relevant. These are the homicide victims, right?
Yes.
Just turn over everything in.
Well, Judge, I can tell you, because I'm a part of it, it's not necessarily we have to turn it over, we have to make it available for inspection. We
Yes.
have a number of dates, we
Okay.
scheduled that, we've told them they can come again. There were multiple days when we sat there and waited for their investigator, came hours late.
She's lying again. So I'm going to
If I may finish, Your
Hold
Honor.
on.
She's lying. So this is about Sack Chaser and Juvie's phones, the deceased victims. Their phones were in the car. Defense just wants a copy of their phones, like the download of their phones. State just said that they've tried to schedule it and the defense is always late or doesn't come or something.
She's lying again. So I'm going to
If I may finish, Your
Hold
Honor.
on.
I was the one who was personally there that day with him and our investigator. We continue. Anytime they want to come see it, we have had an investigator from our office, the computer, and their investigator there. Sit
Is
down
this something
and
where they
anytime
can
want.
just stick a thumb drive in and download what you got and that's it?
Make a copy of it? No, Your Honor.
They're
Why
withholding
can't
it.
they do that?
As Mr. Griffin said, Ms. Buckler is the one with the most knowledge of all the contents of the phone, and that's why it's all discussed in her response. But regardless.
Bitch, why the fuck you come over here?
Make it available, we have and continue to, anytime they
Yeah,
want to
but make it
schedule.
available, one of the things
For
they make it
inspection.
available for is to copy it. They're allowed
If
to
it's
copy
available
it.
to be copied. Ms. Buckler, and that's why I did this one of the motions, we said that she would be prepared to argue, is of the opinion that she
He
filed.
already went
whole-
to trial. He
Exactly
already went to
right.
trial?
And it was
He already went to
withheld there.
trial.
Yes.
This is the decedent's cell phone. Okay, over the state's objection, this motion is granted.
W. I said this in my last video. I was like, just hand it over. It's the victim's cell phone's copy. That's very important evidence. This is Brady evidence. Thank God he
Bruh.
figured it out and went through the weeds there and was like, you already had a fucking trial.
Make the appointment, go over there, download everything that they have.
I will get my expert to do our own download
Okay.
of the phone. So where, we need the parameters though, so when.
There's no
where-
parameters, just make an appointment. Listen, I'm not gonna make appointments for you.
Okay,
If you all can't work that out, I don't know what to tell you. Okay, go appeal to the 4th DCA and say, we can't make appointments and treat each other like civilized human beings when we have to come over and download.
He said, listen, I ain't making no appointments for y'all. Y'all are adults. This is a professional environment right here.
For over a year,
Damn.
nothing's been done. That it does not qualify as an ongoing investigation. In addition to that, that they are obligated and they cannot hide behind the open investigation provision when it deals with information on charges against Mr. Demings, specifically the murder and the tampering case. And they indicated that the tampering case is somewhat going to be used in the murder case, as I think they said, consciousness of guilt.
Oh, yeah, I remember I read that. They said since Melly was trying to keep his girlfriend away from court, allegedly, with the coded language notes through another inmate who then told Bortland over the phone, they're saying that's consciousness of guilt, and they want to show the jury that in the murder trial.
I know the court has told us to talk to Mr. Demings concerning the potential conflict, and they have alluded to the conflict today. He doesn't know how to make that decision because he doesn't have sufficient information to determine whether or not he wants to keep Miss Liberty or any of us. It's more like 14 months that they've sat on this information.
State, listen, for the most part, I agree with what Mr. Avison just said. You have a continuing obligation, so when you agree, anything that comes from any source that is relevant to the charges against Mr. Demings, you gotta turn that over, right?
Before we get to, yes, Judge, there is an ongoing obligation for things relevant to his homicide or to his open tampering charge that would be turned over. Having said that, Judge, we weren't noticed for this particular motion today, and we would rather have a full response. The notice says motion to compel. We didn't actually receive this with Miss Liberty's pleadings. This one actually came separately, and we only received it, I think it was 2 days ago.
214 it was filed. And
And I, honestly, it says motion to compel. Ms. Liberty has filed so many that we were unaware that this was going to be argued today.
Let me hold on that. All this stuff belongs to Miss Liberty. Has she asked Apple to just give her a copy?
I believe her lawyer did write a letter asking for the return of all, and they said they would give you nothing.
They're not gonna give her her own thing?
Nothing.
so let me just.
So Apple won't give you your own stuff?
They said Barbara Sheriff's Office. Apple then did sit with me, I went through it, I have access to the iCloud, but no, they will not give me the return of what they got.
Did you have access to the iCloud that has all your stuff on it?
Of course, that's just my iPhone.
Well, then that-
It doesn't matter. They have it in
No,
their
no,
possession.
listen, I don't disagree with you, but you all are a little more adroit in these technical matters than I am. There's nothing that's outside of what's in her iCloud. Everything's in it, right?
I don't know. I don't know what they've seized, because I believe there are additional search warrants based upon the original search warrant.
Well, I don't know anything about that, but as
I
far as the
understand.
search warrant, I already ordered you to get that, you got it. As far as police reports,
State didn't respond to that. Is there more search warrants we don't know about? That's the vibe I'm getting from that non-answer right there.
It's still an open, it's still an open investigation, Judge.
They're just bullshitting this
I
whole
disagree
case
with
still.
that
Still.
pursuant to statute, but there are no police reports.
There are no police.
Because nothing's happened.
No.
Okay, so there's no police report. The names of any witnesses and all witness statements related to the Apple iCloud, that would be like a custodian of records, right?
That would
There's
be-
no other witnesses to iCloud except a custodian of records.
It would be Apple or the records custodian certification.
Have you listed a custodian of records?
There's nobody to know, Your Honor. We have not
You have
listed
not.
either the homicide or the tampering
So
case.
you would have an ongoing obligation to do that.
We
if you
have-
wanted to use any of this.
We have an ongoing obligation to turn over anything that's relevant or may be relevant to either of those two cases. We are complying with our discovery obligations.
This is what I'm gonna do. Go ahead, sir. I'll give you the last.
I find it hard to believe that there are no investigative police reports saying they've contacted witness A, witness B to verify or to corroborate whatever is on, whatever they seized pursuant to their original search warrant. I find that hard to believe.
That's a great point. That is bullshit. That is horseshit for sure.
A year, they come in here and file a motion indicating that Miss Liberty must get off the case because of the conflict. I find that very hard to believe. And I find it hard to believe that they, in their investigation, did not take statements of potential witnesses. And they say it's interrelated to the murder and tampering. So
You said something to him.
Listen, they're in a continuing obligation, okay? If we get somewhere down the line and something is put before me that they had material sometime long before February 8th, and Mr. Griffith is standing here and telling me otherwise, he's going to have a very large problem, right? A very large problem. So I'm not playing with it.
and I appreciate it.
So at this point, I have to take everything at face value.
And
But that being said, I'm going to grant your motion in part as follows. State, I'm going to give you 20 days to turn over anything that you have received regarding the Apple iCloud or Braven Liberty that you intend to use at either trial, okay?
Damn. He only gave him 20 days to hand all that over. I wonder if they even found anything on there. I mean, it was just about Danny Polo's identity being leaked because of his own wife. It was pretty easy to find by anyone that could do it, a few Google searches.
Make it as detailed as you can, because if we get forward to the point of a trial and they stand up and say, Judge, they didn't disclose this and now they're trying to use it, you will not be using it. It will be barred as evidence at trial. Okay? In the Apple iCloud, download that you expect to use at trial in either case, in Mr. Denner's case. All right, and I'm basically ordering you to comply with the rules, which you already should be complying with. Well, he has to turn that over.
Okay.
Whether it's in the affidavit or not, whatever it is. He has to, as it relates to Mr. Demons, he has to turn it over. As if it only solely relates, if Miss Liberty, if they're, I have no idea. If they say Miss
The judge, I have no idea.
Liberty went and did XYZ with witness A,
That nigga tired.
I don't know how that wouldn't be considered as relevant to the case. If they want to introduce that in the trial, no, then they're going to have to turn it over within 20 days. So I think you're going to have your answer in 20 days.
We'll see what the response is, and I'm sure we'll be.
In light of these allegations that I'm, I guess, trying to murder or take a hit out on Danny Polo, it's came to my attention that Danny Polo might be suffering from some type of mental illness at this point. We heard in the last trial he thought somebody had a hit out on him. He had lied to the court. We found out he had pictures out there in the public domain. And now, 2 years later, I'm being accused of trying to kill Danny Polo. I don't know exactly, because we don't know the affidavits, but it's a homicide detective and it's Danny Polo's picture, and I'm directing gang activity. I think at this point, Mr. Detective Polo is in need of an evaluation to determine if he even has the capacity to sit and testify.
Wait, I didn't know the accusation for all those search warrants were her attempting to kill him. I thought it was just leaking his identity. Is that equivalent to trying to murder him because it could put him in danger, I guess? She basically just said this guy might have some mental issues and may have some shit going on in his head that's not there and be paranoid.
In this case or any other
Probably
case,
is.
because he has some type of paranoia about being murdered at this point. That's where he's going at a defense attorney, saying a defense attorney is trying to murder him now. Because that is the premise of this so-called investigation, is I'm trying to kill Danny Polo. That's the witness that they're saying I'm tampering with because he was impeached, not once but twice.
The requested
Is that he undergoes a psych evaluation before he's allowed to testify further in this case.
I think, because I don't entertain an ordinance motion, but I think you're talking about challenging the competency of the witness, correct?
Oh, yes.
Okay, so I think if you have that concern, I guess you need to file the appropriate written motion.
Thank you, Judge.
Okay, anything else?
Dude, what the fuck is this trial? And now he's about to talk about the porn because they don't want anything else on Zoom anymore because there was a porn leak in the Zoom.
Expand that order level to allow her only to appear on Zoom.
I would be happy to allow all the lawyers to appear on Zoom, but based on what happened, it would cause me to enter that order.
Well, I think
I would need to know, because all of your names are out there in the public domain.
She's just asking for Friday for the hearing of Mr. Barris as to
Sure.
that Ryan Hamilton motion.
But even going forward, the court can limit people who come in and can only just allow her in, forbid everybody else from coming in.
I completely agree with you, but based on the creative nature of the viewing public out there, if I get 7 or 8 or 9 people that all sign in on the same name, then I'm not quite sure how you want to handle it.
Well, we can verify which account Ms. Buckler actually is. That's the case.
I would.
I'm sure there's a way to make a Zoom call secure, right? Like, what fucking year are we in? COVID was 5 years ago. This fucker hasn't figured this out yet. All right, that's it for the day. And there goes Melly right there. Smiling at the family. Going back to the same jail cell he'd been in for 5 or 6 years. Sorry, it's actually not funny, but I'm laughing at how absolutely fucking insane that is. Yeah, that's pretty much it for today's video. Apparently there's a hearing on Mariah Hamilton on Friday, so I'll cover that too. Melly's girlfriend. She is an important witness. Comment.
Let me pause that. I'm gonna check some more YouTube, see if there's anything you know watch. RC hilarious whole moments. Might watch one of these hoes. We gotta watch something. We gotta watch something like cheer you up a little bit or something. You know, something better on your mind. But we just gonna watch this REC shit.
So when Knuckles was beating me and Luigi ass, you were showing love back?
It ain't even like that though.
You were showing love back?
Come on, this first one. I was expecting that.
What I tell you about sitting in my seat, nigga?
Yeah. Go.
They said just do ready, go.
Wait,
Don't jump. Let's go meet up.
They gonna meet up. Oh, my fault. I'm stupid. My bad.
Hey man,
I just need my pills.
Oh no. Oh,
what?
Oh,
I saw that. Oh fuck. I fell. Nope.
Let's go.
Ready? Go.
We gotta keep moving.
Who's doing something?
Oh fuck.
Oh, that's the shit, bro. Right. Oh, that was me.
Oh my god, I can pull.
That was me.
Right. I gotta be patient.
Bro.
Fucking jump to them checkpoint. What checkpoint?
No, there's don't go yet. Don't go.
I fell. Can you go back? Go back.
Go back in the
No.
Oh my fucking gosh.
Good.
Game sense.
Alright, ready? Oh fuck.
What? No.
Niggas really. They sorry almost. No, they sorry at every game.
Set.
Oh no.
Man, y'all niggas, man.
Nah, who fell right there, bro? I fell.
Alright.
You gotta. Oh, Jay. Hold on, Jay. We didn't fell.
My dog's barking.
I tried to jump to the next one. That'll be the smart. Look, yeah, you like it. You see, ain't nobody playing.
Damn.
What the?
Nigga barking his ass.
Just
Leland. If you fall,
You good, Lee?
if you fall, we're going far. Pull somebody up.
You good, Lee?
No, it's Dan's old ass.
Y'all are pulling me.
No, you have to pull somebody up, Lee, please. I swear, I'll get off this bitch.
Nice.
This is not me.
Move.
Coming in. Hey, come on.
No.
No, they were leaving. The things were leaving behind us.
No, they weren't.
I seen them.
No, Leland.
They go with you. They go with you. I was watching them host too.
What is you scared for, nigga?
Oh my god. Oh my god.
Oh my god.
Fuck, Leland, we're trying to tell you though.
These niggas crashing out on God.
You already
You know that's you.
ready?
Go back. Des, go back.
Oh, I cannot watch this shit for that long now. I can't lie. My train of thought's getting lost. We're gonna watch this shit real quick and we're gonna get some games.
Some taken off an ankle monitor. Broward County Sheriff's Office submitted a massive response asking for the entire lawsuit to be dismissed. Stick around for the last half of the video while I read BSO's response. Hit subscribe right now. Thank you guys. Let's go. All right, first look at Melly right here. Emergency hearing for his ex-girlfriend over that whole ankle monitor situation because she's on an ankle monitor now. So let's see how this goes. Melly also requested to be present in person during this hearing, so that's why he's there.
The reason that we're here today, this is an emergency motion to vacate, which is filed on behalf of Mariah Hamilton who is a material witness in the case.
Quick reminder on why she's being called as a witness. Her own mom put her in this position because she talked to the police the next day, or the same night even of the murders, I don't even remember. I think it was the next day, and told the police that she overheard a phone call between Melly and his girlfriend Mariah at the time, within an hour or two of the murder, like within minutes of the murder actually. And Melly was walking through the woods and telling her what just happened. We don't know if he confessed to her or anything, but we just know they had a phone call. But then Felicia, her mother, was a witness in the first trial and didn't give any clear answers whatsoever. She was a very difficult witness, and she basically regrets talking to the police the first day. So her mom put her in this position because they were like, wait, you had a phone call with the guy we're charging with murder right after he committed murder? Oh, and Mariah's been on the run pretty much, like avoiding the subpoena and wanted by the court to testify as a witness. So they finally got her and they put her on her ankle monitor. She was released from custody like a week or two ago.
So, Mr. Griffiths, let me ask you, since you're the one that's here, with the state's position on the defense emergency motion to vacate, they want me to take the ankle monitor off this one.
No, Judge, State would be objecting based upon the fact that the writ was issued in the first place and the difficulties in securing her presence for trial.
Straightforward. They're saying if we take this ankle monitor off, she might just fucking disappear again.
Okay, so listen, again, I'm certainly not foreclosed to reconsidering this at a later point in time. And for the record, I did read the motion, and there's a lot in here about 942.03, and Mr. Barris's position is that that's not applicable to Ms. Hamilton, and he's probably right about that. That's why I released her from custody the first time that I saw her. However, I did look at everything in the electronic docket. I was not the trial judge back then handling this case, and I'm not making any judgments or finding any facts about it. But there does seem to be an awful lot of pleadings, emails, letters.
All right, so I ain't gonna lie. Let me pause this real quick. First game I'm playing, my rivals. We gotta get up hiring fucking Elo nigga. I gotta get better.
There were some issues
Maybe
with,
Fortnite.
Cooperation with witnesses, so there's an easy way to do this, and there's a hard
Something.
way to do it. It would appear the prior judges that handled this case came to the conclusion that Ms. Hamilton chose the hard way to do this thing. I don't think anyone that's not charged with a crime should be under any form of security anyway under normal conditions. However, this isn't a normal condition. The state's identified her as a material witness. I do have 902.15. Again, this
Sounds like he's going to deny this and she's going to remain under an ankle monitor.
is only applicable
Yeah,
to someone
probably.
who's facing life imprisonment or the death penalty. Mr. Devins is in fact facing the death penalty. All she, just like any other witness, has to do is come to court. And either side wants them to come to court to a deposition, to a motion, or to a hearing. And as soon as that responsibility is concluded, that will end the security that's been put in place, which I have chosen to be an ankle monitor as opposed to posting some form of monetary bond. So at this point, respectfully, I'm going to deny the emergency motion to vacate. It's going to stay right the way it is. And again, I'm not foreclosing either side filing whatever motion in the future. If you want to need time for an evidentiary hearing, I'm happy to do that. And again, I'm always ready, willing, and able to listen to any evidence, witnesses, or testimony that either side wants to present regarding the issue, but based only on what I've read in the electronic docket and what's been in the pleadings, because that's the only thing that's been presented to me. I'm just not comfortable doing anything else at this time. So that's what I'm going to do.
Your Honor, I don't understand where you're deriving your authority from. Can you explain that for the record?
Well,
Jesus. Her lawyer's like, I don't understand. Can you please explain it? That's Mr. Barris right there, Christopher Barris, I believe his name is.
I mean, actually, I usually don't have to answer lawyers' questions, but this is security. The security is the ankle monitor. I mean, the alternative would be,
If you're new to the channel, please hit subscribe. I appreciate the support. Back to the video, boys.
do you want me to take the ankle monitor off, put her back in jail, and set a monetary bond for her to post? Is that what you want me to do? Because that's what security means in the statute, just like any other bond statute. So that's where I'm getting the authority from, sir, 902.15. So I'll enter the appropriate written order. Again, Ms. Hamilton, same as when I met you before for the first time. If any side subpoenas you to testify at a deposition, at a hearing, or at a trial, whoever that may be, state or defense, all you gotta do is show up, honor the subpoena, and then as soon as the trial is over and the matter is resolved, we will also resolve your current situation. So, Mr. Devins, all pending motions remain set April the 1st at 1:45 p.m. His trial remains set September the 10th at 9 o'clock.
All pending motions for Melly's stuff will be April 1st, like he said. Important stuff with Melly's lawsuit against BSO. BSO's response to Melly's memorandum in support of his petition for writ of habeas corpus. January 17, 2025. Status conference hearing. Litigants in court discussed numerous procedural bars. This court ordered the petitioner to file a supplement response to address these numerous procedural issues. Court scheduled a final evidentiary hearing on March 13th on the merits of the habeas corpus petition. Petitioner filed their memorandum on the procedural issues. Petitioner Petitioner's memorandum on these procedural issues offers no valid legal or factual basis as to why the petition for a writ of habeas corpus should not be dismissed, nor could he, as the law is clear on these issues. Strong claims. The issue of Melly failing to exhaust administrative remedies, but in doing so for a second time has both misstated the applicable law on requirement of exhaustion of state court remedies. Remember, Melly's team said that they exhausted all state remedies and they had to go to a federal court. This reply is basically saying that's cap. To dumb it down, just as petitioner believes himself to be exempt from BSO's jail rules and regulations and wishes this court to modify the legitimate security measures BSO has implemented, he believes himself to be exempt from clear legal precedent on these procedural hurdles, including the statutory requirement he exhaust his state court remedies prior to seeking 2241 before this court. Petitioner should not be treated any differently than any other inmate, be allowed to skirt by their clear legal barriers that prevent his action from proceeding. It is evident now, as it has been since his action was initiated, that a final evidentiary hearing is not necessary and the one scheduled for March 13, 2025 should be canceled and this action dismissed for petitioner to seek remedies in the Florida state court system if he so chooses, where BSO will be prepared to respond as needed. Jesus. So they're saying cancel everything. This shit needs to be dismissed. All right. Timeliness. Petitioner claims that he is not appealing a Florida court order or judgment and that his petition is timely because the constitutional violations are ongoing. Offers no persuasive legal authority as to why he should be otherwise exempt from the plain language in 224D1 that subjects habeas petition to a 1-year statute of limitations starting from the date from which facts supporting new claims could have been discovered through the exercise of due diligence. The fact that petitioner's counsel agreed that his video visitation and phone privileges were properly suspended would work against any argument for tolling, especially with respect to the challenges directed at the revocation of those privileges. Tolling basically means a lawsuit can be filed even after the statute of limitations has expired. BSO is basically saying fuck now. Restrictions imposed on habeas petitions filed by pretrial detainees, including the statute of limitations, are the same as those filed by a convicted prisoner, despite petitioner's claims to the contrary. Holy shit, what? For real? Pretrial detainees are the same as convicted prisoner. That's kind of crazy, right? Failed to exhaust state court remedies again. Now claims he is not required to exhaust state court remedies because 2254, unlike 2241, contains an exhaustion of administrative remedies conditions for inmates serving a sentence under the judgment of a state court. And petitioner is not in the custody to any final judgment of state court. Petitioner also states, but as is apparent, petitioner is not a state court convicted felon seeking to challenge his state court judgment and thus has not asked this court to disregard the requirements. Petitioner's contention that exhaustion of state court remedies is not required for pretrial detainees who raise constitutional issues in a 2241 petition. Wholly without merit. Available remedies. Petitioner has remedies in state court for all of the constitutional injuries he complains of concerning his close management style of housing, including the restrictions placed on his phones, video visitation, and in-person access to Raven Liberty, who, as discussed below, is under criminal investigation for witness tampering. Petitioner claims that this court should not defer to a state court judicial proceeding that is not available and whose eventual exercise of jurisdiction would moot this controversy by awaiting petitioner's conviction, and that he has done all he can to obtain relief in the state court and that quest was unsuccessful. He also claims that the state court ruling was not appealable or reviewable as a matter of right, and the trial court orders are in criminal cases are not
basically
right for review until the entry of final judgment when he's sentenced or convicted.
This
is false. BSO will not provide legal advice to petitioner or petitioner's numerous counsel. They're saying, hey bro, your lawyers are dumb as shit, this is wrong. There are numerous avenues to raise his concerns in Florida courts. In Florida, petitioner's request for release from custody is concerned, which petitioner appears to be abandoning as request, as his court made it clear it was not an available remedy, and petitioner has not addressed this in his memorandum. Petitioner can file a petition challenging the no monetary bond order from his criminal case today if he so desired. As far as they challenge his conditions of confinement with respect to his close management style of housing, close management. Wait, who said close management? Was that Melly's lawyers? I think it was. Where he's placed in an entire housing pod by himself, and the lost video visitation and phone privileges is properly challengeable as a writ of habeas corpus under Florida law, citing Banks versus Jones. Likewise, a petition for a writ of mandamus is the proper avenue under the Florida law to force a government official to comply with statutorily mandated duties and non-discretionary obligations. Petitioner could also file an extraordinary writ of mandamus and argue BSO was not giving him access to counsel in violation or challenge security measures taken by BSO when it suspends his phone and video visitation privileges. Wait, why are they giving them advice? They actually are giving advice. Petitioner could also file another motion as pending criminal case if he wishes to readdress the issues of phone availability and video visitation and other conditions of confinement as he had in the past, and BSO will appear and address as needed. Why are they literally giving Melly Steele like, hey bro, drop the federal lawsuit. You could have done this in state courts. His lawyers previously agreed that his phone and video visitation privileges were properly restricted due to petitioner repeatedly violating jail rules, which is why BSO finds it puzzling that Melly now finds this action without even first attempting to readdress the issue before the trial court presiding over the case. So I remember them saying his lawyers agreed to this, but I don't remember where exactly they agreed. Maybe in person? I think it was in person, like in a hearing or something. If petitioner now believes the phone and video visitation issue should be revisited, certainly he can file another motion as criminal case and BSO will appear and address that. Or petitioner wants to file a separate petition for a writ of mandamus or a petition for a writ of habeas corpus challenging either his no monetary bond or his close management assignment or BSO's alleged non-compliance with Florida statute. Florida Attorney General will respond. In either event, Melly has multiple avenues in state courts for all the issues he raises in this action. All right, interesting. For one, Heck versus Humphrey bars petitioner's actions to extent he is contesting the factual basis for his pending witness tampering charges against him and Broward case, blah, 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 and his co-defendant for pending capital homicide case, Henry Cortland. The factual basis for these pending criminal charges were also the factual basis used by BSO's Department of Detention, command in revoking petitioner's phone and video visitation rights. As a security measure, as petitioner used these privileges as a means to criminally tamper with the witnesses outside BSO's jail. Petitioner's Heck barred from challenging the factual predicate of these crimes, which he's attempting to do by challenging the basis for BSO restricting petitioner's privileges. So they're saying since he's charged with witness tampering, he can't challenge shit right now because it's criminal charges. To dumb that down, Melly, by filing this petition, is claiming BSO had no justification in revoking his video visitation and phone privileges, and claims that he did not tamper with witnesses for his pending homicide case outside the jail, nor did he direct gang activities. In sum, he is challenging the factual predicate for both BSO's justification for suspending a few of his jail privileges as a security measure and the factual basis for his pending witness tampering charges. Yeah, directing activities of a criminal gang, describing the factual basis for witness tampering charges against petitioner in Broward case based on him using BSO's jail phone and video visitation system. Melly is improperly attempting to challenge the factual basis for his pending witness tampering charges by filing this petition and the criminal investigation into one of his attorneys. Jesus. This case should be stayed or dismissed pursuant to Heck so petitioner can challenge in the proper forum. Blah, blah, blah. Broward County Sheriff's Office respectfully requests that this petition for habeas corpus be dismissed and or denied and attorney fees be granted to BSO for the reasons set forth in this response and in BSO's first response. Wait, are they asking Melly for attorney's fees? Is that what that means right there? They want him to pay for the state attorney? Interesting. Looks like we might not have many hearings until April 1st for Melly. So
damn.
like fucking 5-6 weeks from now.
Oh shit. WV then, man. We gonna hop into some games, bro. We gonna hop into some games, chat. I think we can start with Fortnite. There's an update. I forgot what that update was supposed to be. Ah, damn. 43 gigabytes, nigga. Damn. Free upgrade for the PC version of GTA 5.